Hello all, and welcome to the Bristol Law Society webinar. Thank you all for attending. My name is James Woodburn. I'm a council member of the Bristol Law Society. I'm also a commercial litigation solicitor over at Clark Wilmot. We're delighted to welcome you today to this webinar on hybrid hearings with Adam Griffiths, who will be shortly presenting. Adam is a barrister over at Queen Square Chambers. A little bit about his background. In 2014, Adam was appointed as in-house counsel at a large financial intermediary business in Hong Kong. Adam managed cross-border litigation, compliance to financial regulations and advisory work. As a director of the firm, Adam also oversaw corporate and private client affairs. Adam's practice today covers commercial and maritime litigation and also employment. Before we start, just some housekeeping. Adam will present his talk for approximately 45 minutes. Is that right, Adam? Around 45 minutes?
Sounds about right to me.
Brilliant. And with time for questions at the end. You can ask questions using the Q&A facility at the bottom of your screen. I will pose those questions to Adam, time permitting, at the end. The presentation today is recorded and will be available on the Bristol Law Society YouTube channel later on today. Please note also there's no slides available, but I am told notes can be available if you request. That's all from me at the minute, and Adam, I'll hand over to you.
Excellent. Thank you very much, James. Well, yes, to start with, of course, that there are no slides, and I hope in a way that creates a slightly more conversational tone in this presentation. I seem to remember the last time I was invited to give a talk to many of you, it was on Practice Direction 51U, and we went fairly deep down the whole of authorities and backwaters of the White Book in order to define some fairly niche disclosure points, which are fascinating if you're a lawyer's lawyer. But I thought for this talk we'd take a slightly different tack, pardon the nautical puns, there'll be a few, and we'd look at an interesting case which I had in the middle of the coronavirus pandemic. I recognise that most of us are now sick to death of talking about things to do with COVID-19, but there is a future on the horizon, and of course for many of our purposes that future is going to circulate around commercial litigation, particularly in the High Court, and I want to see what lessons we can learn using this trial as a bit of a case study for future trials in the High Court in the post-COVID-19 age. So, of course, we're all used to using Zooms, as we are now, and Teams and CVP. They are the new tools of our trade, and we've all had to quickly work out how best to use this software in order to operate our businesses. For the vast majority of you who are solicitors at law firms, this will be internal meetings with associates and partners, meetings with client teams and other stakeholders and lawyers. But this talk and the excellent lunchtime seminar series organised by BLS is an excellent example of how this technology can be used to improve pre-existing frameworks. It would be almost unthought of to have 30 of us here midweek listening to me talk in the same place. Zoom enables that to happen, and it almost makes me look popular. So thank you for all being here, and also acknowledging that this is a way in which we can utilise this software and utilise the changes which we've had to adapt to in fairly short shrift in order to better something which has always been going on. There have always been these talks available, but it would be unlikely that we could have the volume or interest that we would otherwise have had. There are obvious downsides to the modern technologies which we're all adopting: lack of personality, awkward pauses, and occasional cat filter mishaps. Of course, the focus of this seminar is going to go on how this technology and how the changes which we've experienced in the last year or so are going to apply to that relatively formal setting of the High Court and the work which goes on there. As I said, we're going to look at one of the first trials of its kind during the coronavirus pandemic. It was a trial in which I was instructed in, and I'll start this talk by giving you a little bit of background about what that trial was, what the facts were. I find them particularly fascinating, having lived and breathed it for a number of years, and what we experienced by way of the litigation in the High Court in this period. Then we'll try and distill some lessons to be learnt from that experience, along with the reported judgment and also the article written on the popular blog Civil Litigation Brief, which is otherwise excellent, save for the article they wrote in relation to this case, I'm sure. I'll start then with a bit of background about the trial. So the case was called Global Technologies Racing Against 5 Degrees West, or 5 West, as it was reported. I was instructed in this case around 4 years ago, and by the time it had reached me, it had already been subject to pre-action disclosure and a great deal of effort by way of alternative dispute resolution. My practice, as James helpfully introduced it, spans commercial and mercantile work, and I'm always particularly excited to be dealing with a case involving boats. It really is a passion of mine. I raced yachts for a number of years to a fairly high level. And this is a case which I found particularly fascinating, given that I've raced against some of the characters who were involved, beaten them on the water, and was looking forward to beating them in court as well. It was one of those finely balanced cases where I had to look in detail at what might be termed the cast list, or all of the witnesses and potential witnesses, to see if any conflicts arose. I was satisfied they didn't, despite knowing some of these people by way of acquaintance or through others. It was, albeit a case of personal interest, one which I felt capable to act in, but that made it all the more interesting so far as the facts were concerned. So then, the facts. The case focused on the Vendée Globe round the world yacht race, and specifically Alex Thompson, who many of you may have heard of. Almost all of you will have heard of Dame Ellen MacArthur. Well, Alex Thompson is a contemporary of hers, but he continues to race offshore, competing in the Vendée Globe and trying to win it. He's seen as being pioneering within the realm of offshore yacht racing, pushing the boundaries of yacht design and racing generally in that arena. You might recognize his image. If you type it into Google, you'll see him doing something which is referred to as the keel walk. Effectively, it's him wearing a very smart Hugo Boss suit, walking out on the keel, the brightly coloured keel of his race yacht, while the boat is heeled over or leaning over to one side. It looks very dramatic, and it was a key piece of marketing for Hugo Boss, who were the title sponsors of Alex Thompson alongside people like Nokia. I was instructed on the other side in this case. So I was once again against Alex Thompson, and this time from a company called Global Technologies Racing. They produce ultra high-end carbon fiber components. Typically their clients are F1 race teams, aerospace, and latterly high-end race teams for yachting. They were picked by Alex Thompson Racing to produce a very specific part, and it was probably the most important part of the race yacht. It was the hydrofoil. Now, hydrofoil, again, I hope I'm not teaching anyone to suck eggs, but it's effectively a blade or a wing which sits in the water, connected to the hull of the boat, and they create lift. And that lift lifts the whole of the hull of the yacht out of the water to reduce the wetted area, so to reduce the friction. That makes the boat obviously go a great deal faster. The cost for that is drag. Obviously, you've got this large object moving through the water at great speed. That creates drag whilst it creates lift. And also, of course, with a boat weighing a number of tons, with all of the pressure of the wind on the sail pushing on it as well, a great deal of stress goes through that part. And it's quite a complex stress mechanism, although we had some brilliant experts as part of the trial who dumbed it down for us in a very clever way, using analogies to things like ponytails, bundles of straws. It was a tour de force in expert evidence and the value it can add to a trial, perhaps a topic for another day. But this part, which Global Technologies Racing produced, was the hydrofoil. It's called a Dali Hydrofoil because the curve of the two hydrofoils as they stick out of the boat resembled Salvador Dali's moustache, which led to some hilarity in the course of the trial. But having produced one of these foils to Alex Thompson Racing's design, they used a design company in Paris called VPLP and a designer called Guillaume Verdier to design this very specialist part. Having installed one of the hydrofoils, they started making the payments under the contract to Global Technologies Racing, and the payments were tranched in order to effectively meet maximum banking facilities over the course of a number of hours. And it was partway through these payments being made, balance of the contract was about $333,000, part of the way through the payments, Alex Thompson was out testing one of the 2 hydrofoils that had just been delivered. There was a loud bang, and the next day it snapped. And it was as it snapped, these payments were part processed. And of course, the brakes were rapidly applied by Alex Thompson Racing to the bank transfers. And what we found, of course, was that a claim and a counterclaim ensued. Global Technologies Racing was suing for the contract price for producing the foils, and Alex Thompson Racing were counterclaiming for quality and standard of work, fitness for purpose, or total failure of consideration under restitution. The trial was listed in London over a couple of weeks. We're skipping out 2.5 years of detailed and painstaking prep because that's not interesting. But the trial was listed in London over a couple of weeks in the middle of the coronavirus pandemic last year. Counsel on the other side was Peter Land from Atkin Chambers. And in the few days before the trial listing, there was a skirmish from the other side. And that resulted in a last-minute application being made by them. They sought permission to re-amend their defence and counterclaim, and also rely on a late-served witness statement. This application was sufficiently late that it risked the trial window. The application ended up being heard 2 days before the trial in somewhat remarkable circumstances. And usually we opposed both aspects of that application. It's an application which ordinarily you might let fly, so to speak, on the basis that it can be cured merely by way of costs or adjournment, but we fought it substantively, and we were successful in resisting it on both points, which helpfully restricted the way the other side could put their case. But this marks the first lesson in trials in the hybrid age. The first lesson is this: the court will now employ technology to protect a trial listing. And I think it's a really important point, because the way in which the court has had to become flexible in terms of alternative technologies and alternative listing procedures now enables them to better protect the thing which is most sacred to the courts and tribunal service, which is the availability of trial slots and the judiciary. The application was fitted into the trial judge's list by Microsoft Teams, which many of you will be familiar with. And it would have been impossible to have heard this if it wasn't for video conferencing facilities, because the judge that week was sitting in Manchester. And so technology allowed that incredibly late notice hearing to be conducted by a judge in Manchester, and both parties' respective counsel, one in Bristol and one sitting in London, to determine the issue. The trial itself was due to be heard in the very attractive surrounds of the Rolls building. It was in the specialist commercial list of the High Court, but it was being heard, interestingly, over the same period as Johnny Depp's libel trial. And the use of the courts in the Royal Courts of Justice complex by Johnny Depp's trial had caused other cases to move, and that had caused a bit of a backlog within the Rolls building. But we were a surprisingly heavy trial in terms of both listing time and also the number of in-person attendees alongside video participants. And so, amazingly, the fantastic new Rolls building couldn't accommodate us. They simply didn't have any courtroom large enough. And so, thus gives us the second lesson. The court will now move hybrid hearings, or move to hybrid hearings, to accommodate personal and technological needs in order to achieve an open hearing. And so not just will the court employ technology to protect trial listings, they'll also move cases readily at the last minute in order to do justice to the parties at a trial. The trial was moved then to Manchester, where our judge was based that week in any event, so there was no need for him to come down from London. We actually had a last-minute change of judge as well to accommodate this. You'll note from section 71 of the Senior Courts Act 1981 that the High Court can carry out its work anywhere in England. And so it's fairly comfortable in obtaining a venue at the last minute in order to carry out its business. It doesn't have the same concerns as Crown courts and the criminal system, where of course they're going to need to produce defendants and have people bought from secure locations. The High Court is inherently flexible so long as you have the right participants. So be prepared to move at the last minute. HMCTS's estate considerations may well dictate that your trials need to move late in the day. Even within Manchester, we found ourselves having to move from one courtroom to another to facilitate the change in platform. And that was a fairly substantial undertaking, given we had 7 or 8 lever arch files and at least a dozen people present in court and having to socially distance. The movement isn't limited to cities and courts then, it also extends to platforms. We started out by cross-examining witnesses over Microsoft Teams, and that was fairly acceptable. Of course, you'll remember that there's a need for strong internet, and although it might not make up a lesson for these purposes in and of itself, there's a good case called Blackfriars Limited. It's a 2020 High Court case as well. It's in the Chancery Division, and that case reinforces the need for participants in any sort of hybrid or online hearing to have a strong and stable internet connection. There's a piece of dicta from the Lord Chief Justice in one of his statements noting how everyone has to be flexible and accommodate the potential challenges as we move to digital technology, but you'll find there's fairly short shrift from the judiciary now if you're lacking in terms of internet speed, or if any of your witnesses are lacking in terms of facilities. And so you ought to bear in mind the need for your clients and their witnesses to attend, perhaps even your firm's offices, to sit in a conference room and use your facilities. And of course, make sure that your firm has an adequate internet connection, because we're rapidly finding that all of our offices, all of our rooms are becoming extensions of HMCTS's court estate, and they expect the same standards from us as they do from their own. So, having been on Teams for the first part of the trial, the judge was receiving considerable pressure from above, being one of the first trials of this era, to try the CVP platform, which is the court's own in-house developed software, in order to accommodate the trial. And that meant us having to move within Manchester. That caused fairly formidable difficulties. It was in fact remarked upon in the judgment of His Honour Judge Pearce, who heard the trial. Paragraph 7 of the report, he had this to say about it. This action was tried in the Civil Justice Centre in Manchester in July 2020 during the COVID-19 pandemic. The location was considered suitable because of the desire to have a number of people attending court, as well as witnesses giving evidence remotely in a so-called hybrid hearing. Although this was achieved, there were formidable technological problems, leading to it being necessary to repeatedly change the platform on which the remote evidence was taken and remote participants listened in. This in turn caused significant delays during the hearing. I ought to note that at one point, in fact, the judge considered proceeding, it's about day 4, considered proceeding with the case without the technology working. And so with the courtroom at capacity and with the public unable to attend in any meaningful way. We were halfway through my cross-examination of Alex Thompson. It was perhaps the most pivotal part of our case, putting many of the points that only he could answer as director of the company and the person ultimately responsible for the damaged yacht. We were stuck. I was about 2.5 hours into cross-examination, and we found ourselves waiting for around 3 hours whilst CVP tried to sort itself out for people to dial in. The judge tried using BT Meet Me, so at least people could listen over the phone, and none of it was working. And so it was at that point he had reference to Practice Direction 51Y, which everyone's worth acquainting themselves with if you don't already know about it. It's the temporary practice direction. It lasts for 2 years, roughly, which is the period in which the Coronavirus Act runs. And it enables the judiciary to hold hearings in private, including without the attendance of journalists and the press. Thankfully, in our case, at the 11th hour, or what was probably the 5th hour of the day, the video platform started working again. And so all of those online participants could rejoin and listen to the trials. There was no need for the judge to invoke that. But bear in mind, there is a risk of it and the consequences that can have. It's probably beyond the scope of this talk to go into 51Y further. It gives various rights of permission on parties who are excluded to make applications, to set aside judgments or otherwise to be included in proceedings. But as I say, it's time limited, and you probably won't find anything like it again during peacetime or outside of a pandemic. But the courts continually reinforce the tenet that justice means public justice, and wherever possible, the courts will look to facilitate this. But from all of these technologically induced delays comes the third lesson, and that is timetable for significantly longer than an in-person hearing. And that's both in terms of the steps that are going to be necessary as part of the trial, but also insofar as reserved days, because these things do throw up not just unrelated delays by technology failing or participants being unable to connect, but also each part of the trial takes longer. Classic example in my view is witness handling. Quite frankly, from my experience in the digital courts, witness handling does not flow as well over the internet as it does in person. You'll find that it is much harder to control a witness when you're dealing with them by video. I find natural pauses to be very important, and they're often used by good advocates to control the evidence which is given in cross-examination by asking a new leading question which refocuses a witness who might otherwise be rambling about something which isn't helpful to anyone's case. It's simply a distraction. That technique is now almost useless because of the slight delays or lag that you have within video communication. By the time you've tried to take advantage of that natural pause in speech, you found the person's already started with the next thing they wanted to say on an unrelated topic. Equally, it's very hard to hear, to see rather, what is being spoken when people are little sort of postage-sized stamps, which is particularly a problem in CVP because there's no way of choosing who is in the big frame in the middle. The software does it all. From my experience, you can often find that your witness suddenly is relegated to a small postage stamp and you can't take those visual cues from the evidence. Equally, neither can the judge. Some judges rely more on visual cues than others, no doubt, and I wouldn't take too much from that. But it definitely means that witness handling is more protracted, and I, speaking to other practitioners, find that some are of the view that the quality of evidence is reduced so far as you're less likely to obtain concessions from witnesses, and you're less likely to be able to control the evidence so that it falls in a way which is favourable to your case. Now, you might think that that's good for justice in a way because it allows witnesses to say everything rather than nothing, but it cuts both ways because if you've got a particularly talkative witness who ends up airing and talking about something which is damaging to your case, even if it's a misunderstanding, then they're going to have the opportunity to do that more over video. So there's an argument that more attention needs to be given as a result of this in terms of preparing your witnesses to give evidence over the internet, reinforcing the need for short, succinct answers, and while of course always staying the right side of the line in terms of never coaching a witness, their evidence being their own, but helping them to achieve their best evidence over the internet, because it is a very, very different environment and one which we're all becoming much more accustomed to. It's very rare for someone to find themselves in court, in the witness box, being subject to a very good close cross-examination. They're much more comfortable at home talking over Zoom or over Teams to their colleagues, and they will fall into those habits which they'll have formed in that context. So getting them out of that mindset is really important, and recognizing that it's going to take a lot longer to deal with them when dealing with evidence and cross-examination. It's probably worth pointing out that in the right case, requesting that counsel's diary is booked for an additional day at the end of the trial. Many of you may well think, what an excellent way of a barrister earning an additional refresher. But I say this coming from this case in that we got to the end of our trial listing and we were still a day short for submissions. It just so happened that everyone had the next day free, I imagine, to rest and recuperate from what was a fairly grueling trial. But we ended up using that day the next week in order to have submissions again coming over the internet. We reverted to Microsoft Teams with everyone back in their respective locations of Manchester, London and Bristol, having drafted skeletons to do written submissions, to do oral submissions by video. It worked very well because, of course, there is no real need for counsel to be present in person for those aspects of the case when video will suffice. But it gives us our fourth lesson, which is remain flexible. Don't promise certainty to lay clients, that's for sure, because these processes are readily flexible and adaptable by the judiciary, and they're not afraid to flex and adapt to meet the needs of the parties, and in order to reach finality as swiftly and as efficiently as possible in any given case. I was attended on each day by 2 solicitors, a relative luxury in this day and age, even in high court litigation, to have 2 solicitors behind me. One was physically behind me each day, which was exceptionally useful, albeit socially distanced, and the other was watching remotely over the video conferencing facilities. Both of those members of the firm were exceptionally useful throughout the course of the trial, and perhaps even more so given the hybrid nature of the hearing. The fact that you don't need to attend physically may well mean, for those of you who are solicitors practicing in commercial dispute resolution, that you're able to attend more hearings. You can do that virtually by logging on to CVP or Teams in a way which might otherwise be considered disproportionately expensive or too much for a client to bear. I think that's very beneficial. I can't emphasize enough how useful in high court litigation at first instance the benefits of having a solicitor attend. They really can't be overstated. It's also, of course, this flexibility allowed for the attendance of other stakeholders. And so the directors of the company and people involved in the funding of the litigation could be present throughout to watch the trial unfold. And that's refreshing. As an advocate who takes some pride in the work that I do, it's nice to have as many people as possible feel enfranchised as part of the process. Because, of course, as much as litigation through the courts is part of seeking justice and doing right by a party, it is also, for many litigants, about having their day in court and being vindicated. And as much as possible, the courts want to enfranchise that, and digital technology facilitates that in a way which nothing else ever has. So that flexibility is exceptionally useful. And you ought not to forget, as part of this development within the courts, the benefits which all of this brings, as well as occasionally the hindrances. So, added to that, the digital communication technology wasn't limited to all of these video platforms, but also, of course, we had the eponymous mobile phone with WhatsApp running, and of course WhatsApp for web, which is excellent. For those of you who are more security conscious in this anti-Facebook age, you have programs like Signal, and of course that allowed us to have what are termed back channel communications. We had a number of groups set up. This is very useful again in lengthy litigation. We had a general group which at moments descended into something which might be described as banter, with sort of 15 or 16 stakeholders within the claimant side giving their views on the evidence which we were hearing through cross-examination, which made for wonderful reading of an evening, but perhaps wasn't the most useful when I was at point 17 of my list of questions for cross-examination. And then we had a separate chat, which was just me, my instructing solicitors. And again, that was very useful, as they could filter out anything which was particularly important and needed to be brought to my attention immediately. And it could simply ping up on the screen. Now that's wonderful when, for instance, you are working on electronic bundles, you don't have the benefit of paper tabs, and your solicitor has the exact page reference you want on the tip of their digital tongue, so to speak. You see it flip up before you without you having to take a few seconds to scroll through the PDF tabs to find it. It is useful, and it's part of modern technology which we all might want to adopt in the future. There's nothing to say that that can't happen in a real courtroom as well, to the extent that it's permitted. when you have an instructing solicitor attending on you, or if you are an instructing solicitor attending on counsel, rather than passing the scrappily written note in manuscript, which is often indecipherable, written in heat of the moment. You could simply type a message over WhatsApp and have it appear on counsel's screen in a legible format, which they can refer back to at a later point without having to lose the scrap of paper. These are all parts of the technology that you might want to adapt and adopt in the future to your practices, and aren't just applicable to remote hearings. We had a number of witnesses from around the world. We flew over an expert witness from Spain. The carbon fibre layup process is distinctly technical when it comes to hydrofoils in yacht racing applications. There are very few people that deal in this specialised area. And so the only expert witness that we could alight on was from Spain. We benefited from the coronavirus legislation, which required everyone else to quarantine during the pandemic, whereas if someone was attending from overseas for the purpose of conducting litigation or taking part in litigation, then of course they didn't have to quarantine. So our Spanish expert was able to attend court each day without having to spend a week in quarantine, which was very useful. But we also had witnesses in America. One of our key witnesses was in Texas, and he was able to, albeit by adapting his sleep pattern, dial in each day to watch from Texas and give his evidence, which again allowed him to feel part of the process. It also, of course, saves a great deal of expense for the parties. Where the court are conducting hybrid hearings, it's fairly up to the parties to decide who attends in person and who attends by way of hybrid means. The court will be adaptable in order to do justice efficiently. The coronavirus pandemic has showed us just how effective evidence remotely can be, albeit with the caveats I've already given. And so it's unlikely that a judge is going to be receptive to arguments from the other side that the witness must attend in person, unless there's some wider policy rationale that they can point to. This gives us, in a way, the fifth lesson, which is, whilst remaining flexible, the fourth lesson, strictly follow the applicable rules, practice directions, and court guides. I've already mentioned the fact that we had 7 or 8 lever arch files in this case. These were painstakingly paginated as ever, but featured the ubiquitous and usual late insertions of pages in the run-up to trial. And so we found ourselves with pages like 275A, 275B. Now that will be very familiar for anyone who conducts litigation to find bundles featuring that sort of alphanumeric pagination. But it becomes almost completely unworkable when you have more than a few of these to marry up electronic and manuscript page numbers. And so when you only have a couple, PDF page 278 may, for instance, be manuscript page 276, and that's fine if you're just adding 2 each time. But with this trial, because pages were slipped in left, right, and centre, so to speak, as is the ordinary case in many of these trials, it made the bundle unworkable when references followed one or the other formula. Going to a specific page within a 8 lever arch bundle when you have thousands and thousands of pages cannot be achieved by scrolling alone. It's almost impossible. And so what most of the judiciary do is use the go-to function within Adobe PDF reader, and they'll say go to page 7234, enter, and it takes them there. But of course, that's going to be X number of pages out from the page which you actually wanted them to turn to if the pagination doesn't marry up. And so it is then, for those obvious reasons, important when dealing with a bundle with page numbers approaching the tens of thousands to make sure those numbers marry up. The court had this to say about it. Again, as Honourable Judge Pearce in our case said this: a separate problem arose from the manner in which the trial bundle had been assembled. It was paginated in ascending numeric order in the conventional way, but with additional pages inserted with an alphabetic suffix. Herein lay the problem. The insertion of such additional pages at various points in the bundle created unpredictable discrepancies between the number physically written on the page and the electronic numbering. Using an electronic bundle, it was only possible to get to the relevant pages by estimating the electronic number and then scrolling through. This is a burdensome task. adding to the difficulties in a hearing which was interrupted for the reasons identified above. It is highly likely to be the case that electronic bundles will be extensively used in the business and property courts for the foreseeable future. However, where some people use the electronic version and some a hard copy version, problems arise if the numbers are not the same. In the case of bundle numbering, the obvious solution is to ensure that the electronic page numbering and physical page numbering match. The need to do this is identified in many places, including in the Supreme Court's Practice Direction 14. It was this point then that led to us being blogged about by Civil Litigation Brief in their humorously titled "Electronic Bundles and Problems at Trial. If pages are added, it is not plain sailing." So it has become imperative that electronic page numbers match the manuscript or printed page numbers. A single bundle, otherwise split bundles, and if you do split the bundles because they're too large to be transmitted electronically, then I suggest restarting your numbering. And so then page references will be, for instance, electronic bundle B at page whatever the manuscript and PDF page number are. Or alternatively, if you're sufficiently equipped with software, you can start your page numbering at a later number. So your second electronic bundle, if you're trying to keep them under, say, 20 megabytes, which is becoming increasingly the norm, you might be able to start your second bundle at, say, page 830, which will keep all of the numbering synchronized. That really is invaluable. You wouldn't believe how much smoother trials run when the parties are able to facilitate that, particularly when dealing with hybrid hearings. It's all the more important in this day and age when witness statements, skeleton arguments, and applications all try to reference back into pages within a bundle, as is the modern way. So really nailing that as a basic is important, and a great example of this fifth lesson to follow the rules, because you can find those rules, they are there. His Honour Judge Pearce also had some nice things to say about the bundling efforts. He said this: an electronic bundle was prepared for the hearing, which was sensibly bookmarked and was optical character recognition enabled as far as possible to allow for internal searching. Further, the pages were mostly inserted so that rotation was not required to read them. This all accords with good practice, for which those preparing the bundle are to be commended. And again, I can't reiterate how important it is when in the midst of trial, particularly if you're cross-examining someone, they give an answer to a question and you think, my goodness, there's something in the bundle which directly contradicts this. And I wasn't expecting that as an answer. No one could have possibly expected it as an answer. But if I can search, I might be able to find that page. It is exceptionally useful to have that characteristic built in. So as far as possible, don't simply scan things through a scanner which creates a PDF, but make sure that the original Word documents or PDFs are all bundled together so that they retain their OCR characteristics, or if they are scanned, to ensure that your software re-enables OCR as much as possible, because it is invaluable. Just for those one or two moments, it might make or break a case. So don't overlook that as part of the flexibility which it comes with modern working practices. Do of course then read the guides which are published by the specialist divisions of the courts, along with the practice directions generally. These are readily updated to take account of modern working practices and the needs of the judiciary. If you've got a copy of the white book, when they send you through updates, make sure to skim it for anything like that, and equally keep an eye open on those specialist blogs for people that are interested in things like civil litigation, like Gordon Exel from Civil Litigation Brief, because they really do provide great insight into what's expected from litigants in modern hybrid and digital trials, because there are nuances and you'll be expected to know them by the judiciary who act in these areas day in and day out. So keep abreast of those alongside these general guidance points. And that takes us really to the future. What does this trial tell us about the future of litigation, and what then have the courts and tribunals said about the future of litigation now that we've all started using digital technologies? Is the genie out of the bottle, so to speak? Well, if you listen to leading commentators on digital courts and the like, Richard Susskind being one of them. He's written an excellent book with a bright yellow cover, very modern, called Online Courts and the Future of Justice. He describes us as being at the foothills of modernisation in the court system. He says that we're essentially doing the same thing we've always done by way of trials. We're just doing it from our kitchen table rather than in court. And that's not really the future. There's much more to be done through the use of AI and other technologies which the courts are yet to adopt. He may well be right about that, but for our purposes, I'd say that amounts to crystal ball gazing. For now, we better accept that most applications, at least most interim hearings, are liable to be heard by telephone or video. More and more court files are going to be maintained electronically rather than in paper. And online and electronic data rooms are going to be relied upon increasingly. And so solicitors ought to maintain the best up-to-date online data rooms accessible by the judiciary as possible. The number of times I've been copied into correspondence from judges who simply can't access documents which solicitors have made available to HMCTS by way of their data rooms is surprising. It's surprising that these issues haven't been ironed out already. It's always open to you to check with the courts and with listing to make sure that your software is compatible for their purposes. As I say, all of our facilities, both electronic and physical, are becoming extensions of the HMCTS estate. And so we better make sure that we all work together. Cynics may decry this as a cost-cutting measure, this move to online and digitisation. They may well be right about that, but at the end of the day, the vast majority of us are jobbing lawyers, and unless we're planning on lobbying against these changes or modifying them through external pressure, then we need to learn how to work within the confines of the system as it develops and adopts this technology more and more. And so what have the courts and tribunals said about that? Well, Lord Burnett of Malden, the LCJ, said in 2020 in his report in November that year, he said this about the business and property courts. During lockdown, 85% of the business and property courts moved to be heard remotely and to their original timetable, and consideration is being given to the longer term potential for increased efficiencies in some aspects of the business and property courts' work. And so they clearly see this as potentially being the future for some of the work of the High Court. Just last month, on the 17th of March 2021, Lord Burnett again released another statement, this time thanking lawyers for all of their efforts over the coronavirus period. And it tempered to a degree that sentiment in his last statement. It again moved away from this idea of a permanent change towards digital and hybrid hearings, but it did say this. We have seen that technology has many advantages, but in some circumstances, it can also have the effect of slowing down work. Over the next few weeks and months, as the number of people who have been vaccinated against COVID increases and restrictions begin to ease across England and Wales, it will be possible and desirable to increase attendance in person where it is safe and in the interests of justice. This will be important to maximise the throughput of work. The interests of justice are wider than the circumstances of the individual case and include, importantly, the efficient dispatch of business in the interest of dealing with all cases in all jurisdictions expeditiously. There will be a continuing role for judges, magistrates, staff and legal professionals in ensuring that the recovery of courts is both safe and successful. Remote and hybrid hearings will still play their part in managing footfall in courtrooms and public areas. And so the efficient disposal of cases looks set to keep CVP and its contemporaries in business for at least a little while longer. I'd be surprised if it was going anywhere permanently. I think it's here to stay. It's even more so in other jurisdictions. For example, the employment tribunals, which I occasionally find myself in, they have an incredible backlog of work. I find my diary being populated well into 2022 with cases in the employment tribunal. And so sometime after the Lord Chief Justice's message on the 17th of March, on the 31st, the presidents of the employment tribunal made it clear that their intention is still for almost anything other than a multi-day final hearing, so a trial, to be by default held on video or telephone. In their statement, they had a number of important points, which I think may well act as something as a bellwether for the future of litigation in the higher courts. They found this: there has been an increase in the disposal rate, a worryingly clinical turn of phrase, or the rate at which cases can be determined as part of these modern working practices. In other words, they're clearing their books faster. The backlog is being stemmed by digital working practices. They said this: in the medium to long term, a mix of platforms, remote, hybrid, in-person, will continue to operate. They've also gone so far as to create a new virtual region, or circuit, if you like. That's going to be introduced so that judges and lay members of the employment tribunal from all over the country can come together, because of course there's no need for everyone to be based in one person. Just as my trial, when I was in Bristol, my opponent in London, the judge in Manchester, the witnesses all over the world, we were able to perfectly adequately conduct aspects of the trial, certainly the applications, remotely. That's what this virtual region seeks to do. Since the Alex Thompson trial then, I've certainly found that the diary is more replete with High Court applications by telephone and video. They're much more familiar across all of the jurisdictions I work in. I spend a great deal more of my time then sat here in my room than I do going to court. I used to really enjoy the train journeys up and down the length and breadth of the country. As I was talking to James, who's the chair of this call today, it was an aspect which I really enjoyed, and I found myself very productive on the train. That's gone. I now just have a 35-minute commute to Chambers in order to appear all over the country. It is invariably more efficient and almost certainly offering a cost saving to litigants. But with that said, and in a bid to outdo Civil Litigation Brief on their bad nautical phrasing, I hope that the lessons learned from this voyage through my topical case will help you to navigate the looming tempest of digital courtrooms to come, because they do appear to be here to stay for a vast majority of work which is non-trial. I can see we've got a couple of Q&As. I wondered, James, if you want to manage those.
Yeah, sure. Thank you for that. I found that really interesting, actually. I did want to say it must have been really frustrating halfway through your cross-examination for just the systems just to break down like that. Has that been your only experiences? Do you find the in-house software reasonably robust for hearings? Or
speaking candidly, it was one of the most frustrating moments of my professional career. You get a sense as an advocate when you have someone not necessarily on the run, but on the ropes. And I really felt as though the tempo was with our case and we were making great gains. And all of a sudden, it all had to stop because the technology wasn't working. And I must have spent 2 or 3 hours, every now and again, the judge wasn't sitting for all of it, outside the courtroom, sort of stress marching up and down. I'm just so eager to carry on. And when we did, that break had enabled the witness to recollect all his thoughts, to go over the no doubt statement and bundle again. And I was starting from scratch. It was really very hard. And it's not the only example, I'm afraid. There are others. Quite often I've found that at the last moment, someone's technology isn't working to the point at which the trial has to be vacated. And whilst the courts are willing to be flexible in their use of technology, they're still fairly reluctant to adopt a telephone in order to hear live evidence. So yeah, there are still problems with CVP. Most of the courts are willing to move to something like Teams or Zoom just to get the trial heard. Yeah.
That's good to know. And I was just picking up on other points you mentioned with, you said sometimes handling a witness can witnesses can be difficult to control. And you also suggested that it's worth kind of booking counsel for an extra day. Is it a case where you think kind of online hearings then are generally longer than hearings in real person?
Absolutely. I think it's almost impossible to find online hearing which is going to be shorter than one in person. The exception might be if it's exclusively points of law, so everyone's filed skeletons and it's just oral submissions. because then you don't have the faff of turning up at court, meeting people, sitting down, etc., etc. It's just straight on the video. As soon as you have any sort of evidence, I think trials are elongated electronically.
Right. That's good to know for, even at DQ level, directions questionnaire level.
Yeah, absolutely.
Like that. Yeah. Okay, then. So I'm just going to check the question. We do have 2 questions here from Jessica Winter-Riley. Thank you for your questions, Jessica. So the first one is, with the increase of number of people on technology, how do the courts ensure confidentiality of the hybrid proceedings?
Well, again, we're back to open justice, and just in the way that anyone can walk in to the trial being conducted in person. For the vast majority of my work, anyone can log on and watch me and watch the evidence unfold. Of course, there are going to be exceptions in cases where you have private proceedings. I've never worked in family, but I understand quite a bit of that work is behind closed doors. And so in those environments, well, of course, I think there's probably still going to be a place for physical presence, because the judiciary can be assured of who's present and who is not. And certainly in some trials I've been involved in, even where they're not confidential or held in camera, then the judge has required all participants to have their video on. So at least they can see who's in the room. And that's definitely true when you come to witness handling, because the last thing you want is for your witnesses or the other side's witnesses to be in the room with others, because you can't see if someone's mouthing an answer to them or holding up a card with words written on it. So it's really important that those issues are ironed out with the other side to make sure that they're on board with it. And quite frankly, having a discussion with your opponent is one of the ways to get around that. Certainly in this case, I had a good working relationship with Peter Land. We were able to call each other, email each other fairly frequently, just to make sure that we were encouraging the efficient administration of justice as much as we could. And that's not to be underestimated, to make sure that both your instructor barrister and the other side have a good direct line of communication, which they would otherwise have physically in court, just by phone or email.
Okay, thank you. And the second question we've got here is, do judges use social media as evidence?
They can do. Of course, we're not an inquisitorial system by and large, unless you're in the coroner's court or equivalent. And so it's up to the parties what they want to call as evidence. But yes, obviously, more and more that people put their lives online, the more and more people can expect that to be used as evidence, both for and against them. So I've certainly had cases where, WhatsApp messages, social media posts have all formed part of the evidence that one party wishes to rely on, and so they'll produce that and put it in the bundle. What you won't find, of course, is, unless you want it to be appealed, is a judge going off on their own and conducting their own research on the internet and looking up someone's LinkedIn or Facebook profile to see what they were doing on Thursday the 17th of March 2019. That won't happen, because of course it wouldn't happen in real life, and it doesn't happen in hybrid hearings.
Okay, brilliant. Well, I think that is it for questions, unless anyone wants to ask a question now. Otherwise than that, I think that's going to be it. I'll just say thank you again for your time.
Oh, there's one more from Simon. Is there anything else solicitors can do to help more? Yes, I'd say one of the most important things to do is to make sure that you're in contact as much as possible with whoever counsel is that you intend to instruct early in the process, because each barrister will have their own experience of this, so long as it's a practice in which they're regularly involved and instructed. And so learning from them and their experiences, because each of these trials looks different. It's not like day-to-day practice in the High Court. There is no standard form at the moment. And so learning from individual experiences is more important than ever. And so having frank and open communication with counsel, who normally will be more than happy to do that as part of the ordinary trial preparation. It doesn't need to be formalised, but simply having a steer from them in terms of preparation and steps is overwhelmingly important. And of course, it's going to be recoverable on ordinary costs basis, because everyone's dealing with this at the moment. So dialogue is important. And to the extent you can, and we couldn't in this case, but having really, really good dialogue in terms of preparation with the other side. So at least you're all of one mind as to how to prepare for the trial, and the court will normally fall in line with that so long as it's sensible. Whereas if everyone's suggesting alternatives and they're all much of a muchness, then the judiciary are going to become quite irate fairly rapidly as to why the parties couldn't cooperate at an earlier point. But of course, that can't be helped in every case.
Brilliant, thank you. If anyone else has got any others? Oh, no, brilliant. Okay then, so thank you again, Adam, and thanks for everyone for joining. That now ends the webinar. Thank you. Cheers.
Pleasure.
Bye-bye.